Thank you for joining us. I'm Rebecca Berger, and this is Justice for All, where you get to hear from legal professionals in the surrounding area. We have a really great guest tonight, Chris Bratton from the Bratton Law Group. Chris, welcome. Thank you for joining us.
Absolutely. Thanks for having me. I appreciate it.
I'm so glad to have you here on this very rainy night.
It's pretty nasty out.
Yeah.
But I appreciate it.
So you do a variety of different types of laws, which we're definitely going to talk to all of them.
Right.
But I always ask this because I'm so curious. You know, did you always want to be an attorney?
I did not, actually. My mom was a nurse, and I'm from the South, actually. So from Florida, went to undergrad in Louisiana, was pre-med biology, but pretty quickly found out myself and blood didn't really mix very well. So, but I had a lot of chemistry, so ended up graduating, again, pre-med biology. So then went to work for a couple petrochemical companies, really just doing analysis, things of that nature. Just found myself to be a little bit more entrepreneurial. And I knew I would always have a cap no matter what I was doing there. So just on a whim, decided, well, I'll take the LSATs, go to law school. So that's what I did. And I've never been afraid to pick up and go somewhere, so I decided to come to the Northeast. So the plan was to come to the Northeast, get a law degree, go back down south, but that didn't happen. Got the law degree, got an LLM, stayed up here, have my own practice.
So you've been up here since that time then?
Yeah, since I first moved up here in '98.
So you said forget medicine, and how about if we just try law?
Right, we'll give it a shot, see if it works out.
So when you were in law school, is there any particular area of law that you were thinking of that you would like to try?
I knew I enjoyed the transactional. I didn't want to be in court necessarily. And I enjoyed estate planning and the tax aspect of it, so that was where I was drawn initially.
Well, and I think it's a common misconception that people think everybody who goes to law school wants to be in court. I think people watch Law and Order and they think, oh yeah, everybody wants to be in court.
Right, that's not the case.
Well, because there's so many different things that you can do and so many different areas of law that you can practice with a law degree. I don't think that people necessarily recognize that.
Absolutely, yeah. There's a lot of different areas that you can go into, and those people that are going to law school now, they'll figure out what they want to do, but I enjoyed the transactional aspect of it.
So what is it that you've always been in the disability and elder care law, or is that where you started out?
From the beginning, I focused on estate planning, tax work, estate administration, and I guess what you would say traditional elder law. So with elder law, mostly asset protection, Medicaid work, that was basically the extent of it. But you'll get there's a lot of overlap between estate planning, tax work, elder law, especially if you're protecting assets, things like that, because we're creating a lot of different types of trust, and you have to understand the taxation of trust and how it affects the clients and its interaction with capital gains taxes and all of those things. But there's a lot of overlap, so that's where I started off. That's always what I've done.
And your firm, the Bratton Law Group, has a variety of different areas that you cover that all seem to kind of focus on, the future, so to speak.
Right.
Whether it be tax planning, estate planning, life care planning.
Right.
It seems that you don't just have attorneys who work at your office, correct?
That's correct. So life care planning is a little bit of a different model, and you typically don't expect to see attorneys doing this. So our life care planning model is more of a holistic approach to the client. So what I found in the beginning was I was doing the estate planning, asset protection, Medicaid, and then along with that, we do the estate administration, guardianship, special needs planning, those types of things. But what I found was the clients would come back and they would start asking about rehabs, and they would start asking about transitioning in-home care to assisted living to a skilled nursing setting, and which ones are the best ones, and what do I do with mom now, and Medicare questions and things like that. So I didn't really have a lot of those answers because I wasn't really in the healthcare field at that point. We were just strictly focusing on the legal aspect of it and asset protection, financials. So what I decided to do was I initially brought on a social worker. And that social worker was able then to assist the families and the client as they transition along that healthcare continuum. And it's just expanded since then. So we currently have a social worker on staff, we have an RN on staff, we have another, what we call an elder care coordinator on staff. They are all certified dementia practitioners. So we take a look at the client from a legal perspective. Financially, we want to make sure that they can afford the care that they need, wherever that may be, whether it's at home or assisted living or skilled. Can they afford it? How long can they afford it? If they can't afford it for the rest of their life, are we looking at, do they have long-term care insurance? Do they qualify for maybe veterans aid and attendance? Can Medicare help out for a short period of time? Medicare will pay usually maybe the first 100 days. Usually people don't get a full 100 days, but 100 days max. And then Medicare doesn't pay anymore.
So what do people do in that type of situation?
And then most people, the default is Medicaid. So they run out of money, and then Medicaid becomes the payer source. And that could be at home, it could be in assisted living, or it could be in a nursing home setting. In New Jersey, Medicaid will pay for any of those. Now there's asset limitations, income limitations. Medicaid is a needs-based program, so it's not quite like Medicare. So if you're a single person, you have to have less than $2,000 in assets to qualify for Medicaid. And if you're married, there's some different rules to that. It can get a little bit complex, but yeah, the laws are ever changing, and really it's more what we find more the interpretation of the law at the county level is what we find to be a little bit more difficult in filing all of these Medicaid applications for the clients.
What are some of the examples of the things that you run into at the county level?
So you'll find that the caseworkers at the county level, you may even in that particular county, the caseworkers may interpret it a little bit differently. Some caseworkers a little bit tougher than other caseworkers. And then you'll certainly find it county to county, they view things a little bit differently. Whether it's we've had issues with calculation of community spouse resource allowance or
what does that mean, community spouse resource allowance?
So if you're a married couple and the ill spouse is applying for Medicaid, maybe they're in a nursing home setting and the well spouse is at home. The well spouse is entitled to keep a certain amount of assets. So it's half of the assets, but it's capped at about a little over $128,000. So if you have a couple that has accumulated, let's say $500,000 in retirement, and they think everything's going well, but maybe then husband has a stroke or there's a diagnosis of some cognitive illness and maybe there's a steep decline, who knows? That $500,000 isn't going to last a long time if you're spending, $6,500 to $8,500 in assisted living or $10,000 to $14,000 in a nursing home per month. The money goes pretty quick. So if you have $500,000, that community spouse is capped out at a little over $128,000. So the rest of that money is obviously at risk. That's a lot of money to lose, and the families get nervous. Am I going to lose all of that money in excess of the CSRA, the Community Spouse Resource Allowance? What's going to happen with my house? What do I do to protect the house? Am I going to lose all of my spouse's income when they go into a skilled setting or assisted living? So there's a lot of questions that they have.
So is there a way to protect that, so to speak?
There is,
okay.
Yeah. There's a number of different ways to do it. It really depends on whether you're in a crisis situation or a pre-crisis situation. So pre-crisis, there's no immediate need maybe, or maybe they need a couple hours of care per week at home, nothing major. But they want to plan ahead because maybe there was an early diagnosis of dementia and we know it's going to progress and it's going to get worse. And it could get too difficult for that well spouse to care for that ill spouse at home. So they want to plan ahead, and maybe we create a trust to protect certain assets. Oftentimes we utilize a trust, and you have to look at the assets that are going into the trust. You have to look at the cost basis of the assets, ultimately what potentially if there's going to be a carryover basis into the trust, and then if those trust assets are then distributed out after they pass away, there's going to be a carryover basis to the kids. So do we structure the trust so that there is a step up in basis to the kids? So a lot of different ways to look at it, and then you have to look at the income taxation of the trust as well, because there's really three ways to that trust are taxed, either simple, complex, or grantor. And a lot of times we do like to use the grantor trust because it keeps the tax rate the same, so that there's no increase in the tax rate. So pre-crisis planning, maybe we're utilizing a trust. If it's a crisis planning situation where there's a stroke, or the spouses, they just waited too long and then something happened and now there's going to be entry into a long-term care setting. Now maybe we have to look at utilizing an annuity or something like that for that well spouse. So for instance, let's say that they have $400,000 in assets. Again, that community spouse is capped out at about 128. So then what do we have, 272,000 or so that's left over. Now some of that may have to be used to pay for that ill spouse, at least a portion of that,
Do they
to their care.
require that it would have to be? Again, is it county to county? Is it?
So that piece of it is really per the facility. So if you're looking at assisted living facilities, in general, they want 2 years of private pay before they will allow the resident to go on Medicaid. Now that may vary a little bit, and you may be able to negotiate that with the facility a little bit. In a skilled nursing setting, they usually don't require that. They maybe want 1 month of private pay or 2 months of private pay or something along those lines, and sometimes they'll take them straight on Medicaid. So you may have to utilize some of that money, depending on where the individual is going, whether it's assisted living or skilled.
In a skilled nursing setting, is that just where they're constantly providing the care as opposed to just assisting the person when you're saying that?
It's a higher level of care, yes. So in a skilled setting, you have more nursing type care. They can't do as much on their own. So in assisted living, you want the resident to be able to do some things on their own. They may need some cueing or something along those lines, but you want them to be able to do some of their activities of daily living. Now, you can certainly have a very high level of care in an assisted living, but then once it becomes too much, like a 2-person transfer or something along those lines, and you need more of a skilled level of care. So if you're in a situation like that, again, some of the money of crisis, some of the money may have to be used for care, but then some of that money we can utilize, and we can utilize an annuity to protect some of that money. So there's a difference between assets and income. So an asset is anything that you own. So Medicaid looks at bank accounts, IRAs, life insurance policies, homes, vehicles. They look at everything. So if we take an asset and we convert it to income, the income of the community spouse is disregarded. Medicaid doesn't look at that. They look at the income of the Medicaid recipient. So if we convert an asset into an income stream, now we've protected the asset because it's no longer an asset. It's actually an income stream. So if I take $100,000 of that, say $200,000 that was going to be used for care, even if we use $100,000 on care for that spouse, the community spouse, remember, gets to keep 128 as the community spouse resource allowance. And then let's say that we take another $100,000 and put that into an annuity. That annuity is going to pay the community spouse. Now, that annuity can be very short, can be a 6-month annuity, so that you get the full $100,000 back in 6 months, or it could be a longer annuity. It could be, 4 or 5, 6-year annuity. Now again, we kind of keep going down the rabbit hole because it keeps getting a little bit more complicated. So it has to be Medicaid compliant. So irrevocable, non-assignable, actuarially sound, no balloon payments. It has to meet certain standards. The state of New Jersey has to be the primary beneficiary on the annuity if that community spouse passes away. So then the state will recover. And the term of the annuity can't be longer than the life expectancy of that annuitant. So if the life expectancy of that well spouse is, let's say, 9 years, the annuity can't be longer than that. It can be less, but it can't be longer than that. So we have to look at the term of the annuity as well.
So basically it's a constant balancing act to determine how can we make this possible for you?
Right.
And I kind of want to talk a little bit more when we come back from commercial break, how your firm really is able to do all of this. Because it sounds, I can't imagine it's not something that it's constant for everything. This is something that is necessary for so many families in this country.
Yep.
So I'm Rebecca Berger. This is Justice for All. We'll be right back after this commercial break.
Hey everybody, my name is Ashley Owens. I am your personal networking concierge, and I host a show on RVN TV called Connect to Success, where I interview power networkers in the greater Philadelphia and South Jersey area. So join me every week, 12:30 on Thursdays during your lunch break, and now on Fridays at 9 and 9:30 p.m. We'll see you next week.
This plus this equals this plus this and this. Don't drink and drive.
What makes a temple owl? Meet Stella. She's wise, fierce, and she's not alone. Temple University, where owls call home. We are the cherry and white. The city is our classroom, and we lead the rush hour, making our mark on every field around the world. A world without Temple, well, that's like the sky without the North Star. Temple, never stop it.
Well, you don't have to do it that far back, Keith. Just do it from commercial break. Welcome back. I'm Rebecca Berger. This is Justice for All. We're talking to Chris Bratton. Chris, before we went to commercial break, we were talking about how people are addressing issues with, when someone's in a skilled care facility and how that can impact finances. And how people, in this day and age, sometimes they think without meeting with an attorney, they're saying, hey, I think I'll just give my house or my assets to, my son or my daughter. Why is that not a good idea?
So unfortunately, it's very common, and there's a number of reasons why it's not a great idea. So Medicaid has a 5-year look back. So from date of application, Medicaid looks back at all the finances, all the transactions for 5 years. What's going into the accounts, what's coming out of the accounts. So they're going to see anything that's happening, anything that was given away. If anything was given away for less than fair market value, then they're going to assess a penalty. So what they do is they add up the value of everything that was given away, they plug it into a formula, and that formula then comes out with a number. That number is a number of months in which they're not going to pay for care. So if you gave away $100,000 and you apply for Medicaid, the penalty doesn't start to run until you're otherwise eligible for Medicaid. So you have to have less than $2,000 and meet the other criteria. So now with a $100,000 gift during that 5-year period, Medicaid's going to say, okay, for the next 10 months, we're not going to pay for care. So you're going to have to figure out how to pay for care. Now, the facility's not going to like that. They don't have a payer source. The children, maybe they can't afford to pay $7,500 to $14,000 a month for the care. So that's problematic. So we don't want clients just to haphazardly give away money without, or anything of any value without having some kind of plan. The other issue is a tax issue. The other issue, which kind of falls into your realm, which we'll get into. If you give away something that has some unrealized gain, so if I bought a house for $100,000 and now it's worth $300,000. So let's say I bought it in 1950 for $100. Now it's worth $300, and I give it to you. You take my basis in the house. So it's called a carryover basis. Now your cost basis is $100,000. Then if you turn around and you sell it and you don't fall under the exclusion, then you're going to pay a capital gains tax on that difference, the $200,000 difference. So now that's an income tax or a capital gains tax consequence to you that could have been avoided if we utilized a trust or something.
Which is really important.
Right. The other issue is, if you're my child and I give something to you, if I give my house to you, what happens if you get a divorce?
Yeah, it can go into potentially be part of the equitable distribution
Right.
in that divorce.
Right. Or what happens if you pass away and your will says, I leave everything, you left everything to your spouse.
Yeah.
Now, I don't have a house because I gave it to you, but now you don't own it anymore because you passed.
Yeah.
And now my in-law may or may not like me very much, but they can tell me to get out and they can sell the house.
Yeah.
So there's a number of reasons that we would prefer you not transfer directly to the kids. Because if we utilize a trust, we can control the tax issues, we can control who's able to sell the house, we can control who ultimately will receive the house. So we have more control over what's in the trust.
Well, and your firm handles all of this. So you're doing this life care planning to determine, are we in pre-crisis?
Right.
So that we can plan for this, or are we in the middle of this crisis? How do we deal with it? But then you also deal with, estate planning itself, wills and trust, and how to protect that. But you're also dealing with the tax issue, because they all seem to kind of come into one
Right.
at some point.
They do. They all overlap. You can't really get away from it. And when a client's looking for an attorney, you have to make sure that the attorney is well versed in all of the areas. So if you're looking for an elder law attorney, they have to understand the tax laws. They have to understand how to structure a trust for capital gains purposes when it goes to the heirs. It may or may not be subject to inheritance tax depending on the class of the individual receiving the inheritance, the income tax consequences of the assets in the trust, who's going to be taxed, because if you don't set it up correctly, the kids could be taxed, or it could be subject to the compressed rates of trusts. So everybody understands what tax brackets are. So depending on what your income is where you fall in your tax bracket and what that percentage is. But you don't get to the highest tax bracket until you're somewhere over, I think, $450,000 or $500,000 at the highest tax bracket, or at least the way it is currently. But a trust will get to that highest tax bracket at a little over $12,000 in income per year. So there can be a significant tax consequence if the trust isn't set up properly.
Well, and it seems to me, because the tax laws, I know in family law, they had major implications. As of January 1st of 2019, there were major implications. But the tax laws are constantly changing, so you must have to keep up on them constantly.
They're constantly changing, and the Medicaid laws are constantly changing, or the interpretation of those laws are constantly changing. So regulations may change, so it's not just, it may not just be the statute, but it could be the code, it could be regulations. So we constantly have to keep on top of the changes in the law, but also how if we're talking about a Medicaid application, how the county is interpreting those laws and what they're doing with regard to approvals and things of that nature.
So what do you think are the biggest common misconceptions in elder law?
Well, I think one is that some people are aware that there's a look back, so there's a 5-year look back. But like you said, some people will just go ahead and start giving away money, which is not a good idea, or they'll give away their house. But also people feel like, well, if I haven't done it 5 years prior, now it's too late and I can't do it, which is not the case. We help people all the time in a crisis situation where they're within that 5-year window, but we're still able to make sure that certain assets are protected for that community spouse, or if they want, potentially for the kids or someone else. And there's so many nuances. There's exceptions. If there's a disabled child, there may be transfers to a disabled child. We may have to utilize a special needs trust. There's a lot of different moving parts in it that you have to take into consideration.
What are some of the common questions that you're asked when it comes to, let's say, estate planning?
Well, with regard to estate planning, I think if you're looking at estate planning and elder law, one of the common misconceptions is that people understand that for the IRS regulations, you're allowed to give away $15,000 per year per person, and you don't have to file a 709, which is a gift tax return. Now, if you give away more than that, you file a 709, and if you claim your exemption, it just lowers your lifetime exemption amount, but there's not a tax if you do that. But with Medicaid, that's not the case. If you give away anything, it doesn't matter that it's $15,000 or lower. Potentially, again, if you're applying for Medicaid within that 5-year window, there's going to be a penalty assessed because of that gift. So that's one of the things. The other thing is the inheritance tax. If you're a non-Class A beneficiary, then you're subject to a New Jersey inheritance tax. So Class A beneficiary is a spouse, parent, child, grandchild, anyone in the direct line. There's no New Jersey inheritance tax. But once you start giving things to brothers and sisters and nieces and nephews, and it's subject to an inheritance tax. And then New Jersey did eliminate their estate tax, so we don't have an estate tax in New Jersey any longer.
So if someone was to die without a will, that could definitely cause issues, I'm assuming, tax-wise, correct?
It could, because if you die without a will, now it's subject to the intestacy laws. So if there's no will indicating where the assets are going, New Jersey statute dictates where those assets are going to go, and it may not be where that individual wanted them to go, but the statute's going to dictate.
So in your life care planning portion of the practice, do you think over the past couple of years there have been more people planning, so to speak, for potential critical illnesses or long-term illnesses such as Alzheimer's?
I think it's been, I think more people are understanding what's available to them. A lot of education. We give a ton of seminars. We give CEU credits, try to educate the public, try to educate other healthcare professionals that we exist, that the options are available, because really we just want people to know what their options are. Instead of listening to, my friend's cousin that dabbles in real estate and dabbles in estate planning and does a little bit of this and a little bit of that, just go to someone who specializes in the area and understand the facts, know what your options are, and then from there, just make an informed decision.
What would you say if someone wanted to speak to an attorney who handles this type of law? What would be some of the common questions that they ask?
It depends on whether it's estate planning or whether it's life care planning. On the estate planning side, we oftentimes will just run through a lot of. We start by gathering information, so get a background of what's going on, find out what the family situation is. Is it a first marriage? Is it a second marriage? Are there children of other relationships? Do we have to worry about making sure that one spouse doesn't disinherit the spouse of the other children? We get into all of that, again, utilizing trust. Are we going to utilize trust for minors or for children that maybe are not as competent with money? So we can utilize trust with that. For elder law and for life care planning, it's more a lot of healthcare questions. How do I pay for care? Can I protect some of what I've saved for retirement? Am I going to lose my house? It's a lot of that. And, what are the next steps?
So if someone wanted to retain your services, how would they get in contact with you?
Anyone can reach us at brattonlawgroup.com, or they can give our office a call at 856-857-6007.
Chris, thank you for joining me.
Thank you.
It's been so informative. I appreciate it.
I appreciate you having us on. Thanks.
This is Justice for All. I'm Rebecca Berger, and we'll see you next week.